Mr. Chairman, thank you for the call, and I do want to, at this stage, because we haven't had very much reaction from the government with regard to them, to draw the House's attention to the set of amendments which are in my name and which the House will work through, and going in particular to those to do with union access and the suggestions that have been made there. One of them makes it clear that access cannot be denied if it's required for the conducting of a secret ballot. Now we've had some legislation which is working its way through the House in the name of Tohunare, where unnecessary legislation, I think it's fair to say, but legislation which has a possibility of being passed which requires a secret ballot, and what the member knows is that for that to occur, for the secret ballots which he is now requiring to be held, which are mainly held anyway, there is a need for there's a need for union access in order to conduct those ballots. And what we want to be careful of is employers who unreasonably deny access in order to avoid the ballot, in order to avoid a strike. In fact, I think what would probably happen in most workplaces would be that employees would walk off the job and have their ballot off the job if that occurred. But I think what we need to make clear in the legislation is that where people should act reasonably and work their way forward. There's another amendment which goes to the question that was raised by my colleague Lynn Pillay, where it's our suggestion that the reason for denying access must be given on the same day as access is denied. So, and I think it's not an unreasonable approach. I think that if someone is saying no, you can't come in, then saying why at the same time is not unreasonable. And most employers are bright enough if it's a genuine reason, if they genuinely hold a particular view as to why now is inappropriate for the unions to come in, or even later in the day, then I think it behoves them to indicate the reason for that to the union officials concerned. Mr. Chairman, there are a series of other amendments here. One of them is around communication during collective bargaining, and what the suggestion here is that we just effectively take out clause 9. And one of the problems with the approach that this government has taken under the very poor drafting leadership of the Attorney General is the massive use of parts rather than, and in this case, having one substantive part and what is effectively a consequential part or a very small part, and it means that what would previously happen is that individual issues would be identified and you could vote against clauses. A bill this short would have, under quality drafting, with someone with some integrity leading the drafting process, it would have been drafted such that it was taken clause by clause, because while it's a bill of massive importance, it's not a bill of massive size or massive numbers of clauses, and should have been taken. And that would have been an opportunity for members just to vote no on clause 9. And so what the objective here is to take that clause out of the bill and that way maintain the status quo around collective bargaining. The change proposed in the bill appears to be driven by a misunderstanding of the current legal positions. And again, with the quality of legal drafting that we have from the Attorney General and his very poor leadership, I'm not surprised that there is a misunderstanding in this area. Mr. Chairman. There's some other issues which go to access, Mr. Chairman. Mr. Chairman, which go to access with regard, or the non-denial of access on harassment or discrimination matters. So if there is a matter which the union official needs to get into a workplace immediately because there is a current case of discrimination or harassment, and I think that anyone. I'm just sort of looking around. Oh yes, no, there are a couple of members opposite who have done constituency work in their time, but most people who have done constituency work know that every now and again you get a case where you have some absolutely outrageous harassment of individuals, and to be fair, it is generally the case of small employers, and I want to say that unfortunately it is too often the case that New Zealanders are involved, either as the people being harassed or the people who are doing the harassing. But there are some things which occur within workplaces which are just absolutely unacceptable in our society. Now, some of these reach court, but a lot of them don't, because quite often in sexual harassment cases, the woman, and it is just about always a woman who is harassed, takes a decision that she does not want to put herself through what is effectively a second trial, and the matters often don't go to the police. But the immediate solution, the way of protecting the woman concerned, is very often through the intervention of a union official who comes in and supports and helps to isolate and get some barriers up and to make it clear to the employer that harassment can't continue. Well, I just want to say, why should a woman who is being harassed, often sexually harassed, by an employer have to wait till the day after tomorrow, or at least, maybe day after tomorrow, or if he doesn't agree, it could be 2 days. It could be 2 days before he gives a reason that he doesn't agree for someone to come in, and that in modern society in New Zealand, I think is unacceptable. Although it's consistent with the lack of rights, the lack of respect to individuals that comes from this government, a government which I think it's fair to say in the times of Jim Bolger, he wasn't the best Minister of Labour, but he did believe in the dignity of work and the rights of workers and in human rights generally. And now there's really no one in the government who protects human rights. The Bill of Rights is more or less might as well be gone for the approach that they're taken. There's not a minister who's prepared to, within the cabinet or within the parliament, stand up for the Bill of Rights. And for the rights of individual Kiwis, right down to this, where we have, and it is so sad that we have the Attorney General sitting in the chair as we're legislating away the rights to someone who is being sexually abused and sexually harassed, calling in a union official. We have the Attorney General of New Zealand, who is meant to stand up for those rights, sitting here absolutely numb in his mouth, which is an improvement to his general condition, Mr. Chairman. But we have him sitting there, not supported. And I want to say to the ACT Party, it's about time they took a call on this too. They are the party who has generally stood up for individual rights in New Zealand, the individual right to make a phone call and to ask someone to visit at the place. And what do we have here? We have the ACT Party sitting, not a mumble, not a murmur, not a word from the ACT Party about the individual rights of a worker to call on their representative. Now, I would have thought there's lots of things to do with industrial legislation that we don't agree on, but I thought that one of the things that ACT would have the backbone to stand up for is the right of an individual to make a phone call and to have a meeting. And what do we have?